Hi, Assalamualaikum and good day to our beloved lecturer, Dr. Nazi bin Ismail, and today Group 3 will be presenting our several assignments on the topic of online child pornography. First of all, my name is Nur Najwa Shazwani binti Abdul Nasir, and these are the members of Group 3. For introduction, pornography in the modern sense started with the camera's invention. Sexualized photographs involving children were almost instantly made, exchanged, and collected. Child pornography can be defined as sexual abuse, referring to any material that describes sexually suggestive acts involving a child or called as minor, which are children less than 18 years old. The development of the internet in the 1980s, however, has radically changed the scope and nature of the issue of child pornography and has demanded new investigative and control methods. The rapid change and development of technologies and the internet have caused much more child exploitation in the form of child pornography. Due to its real-time existence and lack of digital evidence left behind after the crime, this form of violence is extremely hard to identify. In Malaysia, cases involving people exploiting the photos of children on the internet have increased dramatically. The most recent case was Richard Huckle back in 2016, where he had committed sexual offences on children as young as 6 months and 14 years old around 2006 to 2014. According to this case, the Malaysian Prime Minister then established stronger legislation to protect the child from being exploited by sexual predators. Soon after, the Sexual Offences Against Children Act, referred to as SOAC 2017, passed by the Parliament. Amendments to the Penal Code and Child Act 2001 were made in order to complement the SOAC 2017. Based on the aforementioned, our assignment will discuss the issues of child pornography in Malaysia and the legislation of Malaysia towards it. Our assignment also will focus on the legislation of child pornography in Malaysia, and the reference will be made to the selected other jurisdiction of child pornography, which is the United Kingdom. The existing legal framework will be examined to identify the weakness of the current legislation in Malaysia.
Hi, my name is Chan Suting. So I'm going to talk about the legislation of Malaysia for the issue of online child pornography. Prior to the amendment of Sexual Offence Against Children Act 2017, for the amendment of the SOSC, these are the existing legislation in Malaysia. Section 31 of the Child Act provides a punishment for the sexual abuse of children. Section 292 of the Penal Code prohibits any activity regarding obscene object. Any persons by printing or producing obscene material or against public decency shall be found guilty under Section 4 of the Printing Presses and Publication Act. Section 5 of the Film Censorship Act stated that any persons who possess, distributes, produce or sell obscene or indecent material was held guilty. Under Communications and Multimedia Act 1998, Section 211 prohibits offences content productions with stricter punishment compared to the Penal Code. Meanwhile, Section 233 made it a crime for improper use of network facilities or network service for obscene materials. In addition, the Content Code makes it illegal to sell or process pornography material, which makes a person liable to prosecutions with a fine of up to 50,000 ringgit or 1 year imprisonment or both.
Hi, Najwa is back, and I will be presenting the issues arise regarding to child pornography in Malaysia. There are two main issues, which is first, the criminal justice system's weakness and the authorities themselves. Malaysia's government refuses to disclose the data on child sexual abuse because it is protected under the Malaysia's Official Secrets Act and only disclosed at the request of a member of parliament. The poor laws on policing and child protection make it difficult to prosecute the child abusers in Malaysia. Besides, Malaysia did not have a specific law that prohibiting online child pornography. The second issue is the development of the internet and advanced technologies. Those engaging in child abuse will connect to internet networks and forums to sell, share, and exchange materials on the internet. These people obtain sexually explicit materials through the internet without the threat of detection.
Now let's move to the enactment of SOSC 2017. The case of Richard Huckle for the 71 sexual offence in London, which also involved some Malaysian child victims, had caused great disturbance within the nations, prompted the formation of a stronger regulation to protect children from sex predators. As a result, the Sexual Offence Against Children Act 2017 was passed. Under Section 4, the term child pornography and sexually explicit conduct was provided. Section 5 and 6 provide the punishment for the producing, making, directing the making or producing child pornography or the preparation to make such offence respectively. Also, Section 7 provide the punishment for any persons who had used a child in the making of or the production of child pornography. Section 8 and 9 provide that any persons who has exchanging or selling child pornography shall be penalized with a maximum jail sentence of 15 years and whipping. Meanwhile, under Section 10, a person was found guilty of the offence stated by accessing child pornography. Section 16 imposes additional punishment apart from the initial sentence for the offender who has a relationship of trust with the child, such as a parents, teachers, and guardians. Lastly, Section 26 provides a rehabilitative counseling for offenders convicted of any sexual offense against a child under the Act. Unfortunately, it does not mention any orders on rehabilitative counseling for the child victims. Hence, SOSC 2017 focused on the punishment and rehabilitation support to offenders only. It failed to meet child victims the needs to support other programs includes in relevant registrations such as rehabilitations, counselings, and compensation.
Hello, my name is Ibti Sameti Othman and I will be presenting about the legislation in the UK. There are a few acts and provisions in the UK that governs the matter of child pornography. The earliest would be the Protection of Children Act 1978. It was made because in 1977 there were many concerns risen on sexual exploitation of children after what happened in the United States. The issue was also made worse when there was an allegation on a registered charity in the UK which was said to be funding the pedophile information exchange. The allegation turns out to be true. Now, another provision that governs this matter is Section 160 of the Criminal Justice Act 1988. Now, the offences under PCA was stated in Section 1, in which anyone will be liable under this offence if he were to take, make, show, or distribute, possesses said material or advertise them. The materials were referred to as photographs, which were defined in Section 7 as film, video recording, and such. Other amendments were made too, which is the definition was then further extended to pseudo-photograph. The age of the child was also further extended from under age 16 to under 80 years old, and this act itself was extended to cover tracings and other works derived from the photograph or pseudo-photograph. Section 160 of CGA, however, is one of a strict liability offence, which it did not matter the motive of the possessor in keeping the materials. If he has custody or control over the image at that time, then he is deemed to have the possession of such material. Now, Section 72 of Sexual Offences Act 2007 provides the provision for those who committed such offence outside of the UK. It regards the offenders if the offender is a UK national or resident or someone who meets nationality or resident of UK at the relevant time.
I'll be continue on the cases relating to child pornography. So the first case is Richard Hackle case, whereby in this case the National Crime Agency UK seeks to track and stop the crimes committed by him by using Section 72 of the Sexual Offences Act 2003, whereby this section allows UK citizens to be prosecuted in the UK for offences they are committed overseas. We can see here the offences committed by Richard Hackle when the authority found more than 2,000 indecent pictures, including rape, which he filmed, photographed, and shared online with pedophile worldwide. He also awarded himself a mark for different kind of abuse of 191 girls and boys. He started to upload pornographic pictures and video to True Love Zone, which is the dark web, since 2013, and he also documented every sexual abuse that he had committed against the children. He wrote a book for pedophile entitled Pedophile and Poverty, Child Law Guide, where in this book explaining how to choose the children and how to avoid being detected by the authorities. The judge restated a line from his book, which he said impoverished kids are definitely much easier to seduce than the middle-class Western kids. Richard Hackle pleaded guilty charges of sexual assault on a minor under the age of 13, making child pornography, sexual penetration of a child, rape of a child under the age of 13, causing children under the age of 13 involved in penetration activity, arranging child sex crime act by writing sexual abuse manual, as well as producing 2,253 pornographic pictures and advertising child pornography. Richard Hackle by admitting 70 offences against the children aged between 6 months and 12 years. He was given 22 life sentence and will be served a minimum 25 years. So in the no-feature case, police found more than 30,000 indecent images and videos of child sexual abuse in his laptop, a total of 601 pornographic videos and images of category A which involve child sexual activity, and hundreds of photography materials of category B and C. He have been charged of making indecent photograph of a child, possessing indecent video with intent to distribute indecent images of children, making indecent images of a child, and possession of indecent images and video of children.
Next is the comparison between the laws in the UK and in Malaysia. Although Malaysia has made some progress relating to laws in child pornography, it still lacks in some aspect. For instance, unlike UK, Malaysia does not have specific provision on the matter of the crime committed outside of the country. There is also no provision regarding the possession and viewing of child pornography. The only provision existed only touched upon making, creating, transmitting, selling and distributing the materials. Lastly, with the non-censorship policy over the internet, Malaysia is almost helpless in tackling online child pornography, as in the UK, it has tackled such matter in which they included materials that were online.
In conclusion, based on the above finding, SOSC 2017 is an essential milestone in the fight against child pornography in Malaysian law. The law further provides a more comprehensive provisions that criminalize possessions, exchange, productions, distributions, publications and acquisitions of child pornography, and criminalize sexual grooming and assault that may lead to the productions of child pornography. However, there is an urgent need for constructive law and regulations to regulate the overall welfare required to protect and rehabilitate internet child pornography victims in Malaysia. Apart from protections and rehabilitations, child victims must be given direct access to compensations by establishing a state fund mechanism or mandatory court order. So, that's all from Group 3. Thank you.